For those of you on the line, hopefully everyone can hear me okay. If there are questions, you can raise your hand. Everyone is in muted mode at this point, but if you want to raise your hand for a question, please do so with the question arrow at the bottom. You can do it there, and at the end we'll unmute people for those questions for Matthew. So again, welcome everyone. As you all know, just as a brief introduction, the IBMA was formed about 32 years ago and is included international in its name from the very beginning, because really the reach and growth of bluegrass music globally was significant back then and is far more so today. As an association focused on connecting and educating bluegrass professionals and raising the awareness of our music worldwide, finding ways to include those outside the U.S. is really critical to the growth of this music and the artists who perform it. Over the years, many international artists have performed at World of Bluegrass on performance stages as well as official showcase bands. And it's always exciting to see how our community around the world has embraced the music and added really your own artistic interpretation to that music that was started here back in 1945. Over the years, the challenges to artists coming to the U.S. have also increased. It can be an overwhelming process for those who lack the necessary information or resources, and it's really just been growing in that complication even more so in the last 1 to 2 years. So we felt it was important to begin the process with a webinar, followed by information that we'll be sharing as an office on our website and through other ways, through email, etc. Information around the visa process and what the IBMA is here to do to help you work through this. We know it's daunting, and so we rely on the expertise of people. I know Eddie Huffman is on the line with me. He's, as you know, director of our convention services, and he oversees the world of bluegrass planning and production. And I'm Paul Schiminger, the executive director of the IBMA, and it is our goal to really bring a lot of quality information to you. And we want to thank a number of people who have helped push this forward for you all in advocacy and for providing information. Silvio Ferretti, who many of you know, is a board member of the IBMA as a representative for the international community. We have Eugene O'Brien to thank, as well as Dave Teague, who have done a lot of work in this area as well. And then lastly, our presenter today, some of you already know Matthew Covey, but he has been very kind in his efforts in the music community to help work through this maze of the immigration process for artists and management worldwide. Matthew, has his own law firm, and he has worked with music and arts immigration since 1996. He's also been a performing member of a U.S. Slovak band, a booking agent, a manager of the Klezmatics. He's also the founding director of Tamizdat, the nonprofit that promotes international exchange, and he is here on this call really as a member of Tamizdat to help us and be a resource for us, for any of us as we need it. So, Matthew, I will at this point turn it over to you, and really do appreciate you joining us today.
Sure, thank you. Can everybody hear me? Or at least can you hear me, Paul?
I can hear you, yes.
That's a good sign. Okay. As Paul said, I am here in the capacity as a person at Tamizdat. Tamizdat's a nonprofit organization that's existed since the 90s, handling a number of different projects to try to encourage international cultural exchange with the US. The primary focus in recent years has been focusing on helping performing artists figure out how to affordably deal with the the maze of US immigration law. But I'm also an immigration attorney, and so the information I'm going to be giving you today is pretty basic. It covers a lot of topics that are of concern to performing artists when they're coming to the US. Obviously, it's not specifically legal advice. If you have a situation, especially if it's a complex situation, and there are plenty of those out there, it's important to get advice that is specific to your case. It's also, in this area, there's an awful lot of word of mouth information or misinformation floating around. Musicians are always trying to help each other, and managers and agents and labels are always handing information around, and sometimes it's good and oftentimes it's not. So part of the project today is to give you a baseline of information that's factual, give you some judgment calls, because there are some gray areas that we have to negotiate. And when we get to question and answer section at the end, I'm more than happy to entertain your questions about what you've heard, what you think it means, and what you can do about it, and all of that. So I'm going to kind of rifle pretty quickly through some basics, and then we'll get on to the question and answer. Paul, can you move on to the next slide? And there it is. Okay, and the next one. All right, so the first question that everybody always asks is, do I need a visa? The way the legal analysis works is it starts from the assumption that if you are a non-US citizen and you will be performing in the US, you always need a visa. Absolutely, that's a place to start from. If you're playing kazoo at your cousin's birthday party, you need a working visa to do that. If you are sitting in a park playing your guitar by yourself in Boston Commons on a Tuesday afternoon in the sun, you start from the assumption that you need a working visa to do that. And then you look for an exception to that rule that would allow you to not have to get a working visa. And there's a number of different exceptions, but there's three, really two, but there's sort of three that are most applicable to performing artists, especially would be applicable to bluegrass performing artists. The first is called the showcase exception. It's not literally a showcase exception. There is nothing in the US law that talks about a showcase exception, but it's something that's interpreted from prior decisions and authorities that are embedded in the US legal code. The basic idea behind the showcase exception is that if you are performing in the US and the principal purpose that the audience is in attendance is not for the sake of being entertained, but rather for the sake of considering hiring you at a future date, that is a bona fide industry showcase. It's considered something that's more of an audition than a performance, and you don't need to have a working visa to do that, which means you don't need a P or an O visa. It means that you theoretically can do this on ESTA, or visa waiver, which is available to people coming primarily from the EU, or better yet, you can do it on a B1 business class tourist visa, which is relatively inexpensive and simple to get. Obviously, there is a world of complexity and confusion regarding what constitutes a real bona fide industry showcase, and we'll get into that in a little bit. Another event that you can sometimes not get a working visa for, is if you're performing at an event which is sponsored by your country. Now, as bluegrass musicians, it's not particularly likely that the Lithuanian government is going to have a consular event in Washington, D.C. and invite a Lithuanian bluegrass band to perform at that event, but it's possible. And if that were to be the case, if the event is free, open to the public, and paid for entirely by your home country, then that's also a performance that you don't need a working visa for. So those are the two. There's exceptions relating to recording sessions. There are exceptions related to academic performances. These are all very narrow exceptions. And if you can define the performance that you're doing within one of those exceptions, then at least legally you've got an argument why you wouldn't need to go through the hassle and expense of getting a performing arts visa, meaning a P or an O visa. And you can get by as a tourist to do those performances. It's important to understand, and this is to sort of back off a little bit, there's a note at the bottom there. It says, not getting paid does not mean you don't need a visa. This is the most common misconception among performing artists, is that if I'm not getting paid, I'm not working, so I don't need a work visa. It makes a lot of sense, but that's not how the law works. The reason the law works that way is because these rules are designed to create protections for American labor. And the concern is that coming to the US to perform and not getting paid is actually in some ways worse than coming to the US and getting paid, in terms of how it impacts other performing artists in the US. I think a good example would be or analogy rather, would be if you've got a bunch of lumberjacks in British Columbia and they want to come over and do logging, chop down trees in Washington State. Well, obviously the government would say, well, you need a working visa to do that. But if those lumberjacks say, well, actually, we like chopping down trees so much, we're willing to do it for free, you can see how the government, and certainly the lumberjack union in the US, would say, well, no, that actually makes it worse, because not only are you taking the jobs from US lumberjacks, but you're also depressing the value of US labor by doing so, by performing for free. So not getting paid doesn't mean you don't have to get a working visa. Can we push on to the next slide, Paul? There we go. The question then immediately would be, what does this mean for IBMA artists? And that's a good question, and the answer isn't particularly simple, unfortunately. After fairly lengthy discussions with the IBMA folks, we've come to a policy, which is that if you are performing at the IBMA bona fide showcase events, and Paul, I think you can help clarify exactly what that is, but we're basically talking primarily about the Wednesday and Thursday night events.
It's the Tuesday, Wednesday, Thursday. During the conference, there are 30 official showcase bands that are selected through application and evaluation by committee, and those bands perform in the convention center during the conference, and they are also given a performance in one of the Ramble venues during those three evenings as well.
Right. So we have, after evaluating how that all fits in with the whole overarching mission of the conference, I am of the opinion that those performances constitute bona fide industry showcases, meaning that an artist, if they're only doing those particular showcases, arguably can come to the US either without a visa on ESTA or the visa waiver, or better, on a B1 visa. Now, that's the law, and that's the way it should work. And that's the way it generally does work. Generally, if a P&O or O visa is not necessary, festivals tend to produce invitation letters that are well written, legally written, for their artists. This is something IBMA will be doing, and those artists can then go into their local US consulate and apply for a B1 visa. Go in and say, look, I'm going to play a showcase event. The showcase event is effectively an audition, and I shouldn't have to be getting a P or an O visa. Those are also incredibly expensive and complex to get, so a B1 should be fine. And by and large, US consulates around the world look at the materials, look up the event online and say, yeah, that makes sense. Here's your B1 visa, you should be fine. That's the theory, and that's the way we want it to go, and that's the way it almost invariably goes. There are a couple of exceptions, and it's important to understand what those exceptions are. The one exception that's important is to know that while I have never seen a situation where an artist got a B1 visa, traveled to the US to do a showcase, and then ran into a problem when they arrived at the airport by running into a border protection officer who says, I don't think you're coming to do a showcase, I think you're coming to play a concert, and sends you home. I've seen that a lot with artists coming to perform on ESTA without a visa. Oftentimes, just showing up at the US airport with your guitar and your amplifier, and the officer saying, I don't know what you're doing, but it looks to me like you're playing a tour, so I'm going to send you home because you don't have a working visa. That happens fairly frequently. I've never seen a situation where an artist goes through the hassle of getting a B1 visa to play a showcase, convinces the US consulate in their hometown that what they're doing is playing a showcase, gets the visa, arrives in the US, and and be turned back because a border officer disagrees with what the embassy decided. Never seen that happen. Theoretically, it could happen, but I have never seen it happen. The cost of the B1 visa is $190 per person, which seems like a lot of money, but compared with the costs, the very significant costs that come with P or O employment visas, it's not bad at all. They generally get turned around in under 2 weeks in most cases, unless there's a problem, which also seems like a long time. But again, compared to the delays that come with getting P and O performing artist visas, working visas, those delays are really not that big a deal, and you've got plenty of time to get those sorted out before the conference. There is one caveat which is important right now, and a strange one. The U.S. Embassy in London is pursuing a line of legal reasoning, which we are not seeing at any other U.S. embassies in the world, where they, at least at last notice, seem to be taking a very, very narrow view on the applicability of the showcase exception, and have been denying B1 visas to artists who are playing showcase events in the US. This is something we're trying to address. I had a meeting with the US Embassy in Belfast last week, and got the impression that they think that this problem is being solved in London. I'm not sure. We haven't tested it yet. We haven't heard whether it's been solved or not. I'm a little scared to try, because I don't want my artists getting turned away or getting their visas denied. But what it means is, if you are a performing artist from the UK and you're planning to come and play at IBMA, and only are going to come to do the showcase events, the Tuesday, Wednesday, Thursday showcase events, and you want to seek getting a B1 visa, talk to us, talk to IBMA, talk to me before you blithely walk into the US Embassy in London and think you're going to walk out with a B1 visa, because things may not go so well. But everywhere else in the world, you'll be fine. So that's the situation with that. If, however, you're coming to IBMA and you're playing the awards ceremony, you're playing one of the commercial events at the Ramble, you're playing on the Friday, Saturday night events, we are of the opinion that these are principally for the general public, and you should be seeking a P or an O visa to do those performances.
And just to clarify what Matthew is saying to those on the line, when we talk about the Ramble, remember the Ramble is two components. One is it provides a performance for official showcase bands as part of your showcasing experience, as well as we have sponsored showcases after the official showcase bands play, and those are the performance-based showcases that Matthew's referring to, that would be like performing at the award show or at the festival, in which a P or an O would likely be necessary, as opposed to official showcase band, that's just principally based on the industry event with the conference.
Right. So in essence, I know this sounds sort of strange, but in essence, what we're saying is, as an artist, you look at the performances you're planning to do, you make a determination of whether it falls within, in this case, IBMA's showcase events, or whether it falls within the festival events. They can help you figure that out. And then once you've made that determination, if you are performing one of the showcase events, we are recommending that you go and seek a B1 visa, which means that going to an embassy and convincing the embassy, the US Embassy, that what you're doing is a showcase event, and assuming they agree, they will issue the B1 visa, and generally they do, with the exception of London. If you are playing one of the other events, or the festival events, we'll call them commercial events, then you can't make a good faith argument to the US Embassy that you're doing a showcase, because you're not, in which case you should be seeking a P or an O visa. Just to clarify one thing that I think I went over pretty quickly, the ESTA or visa waiver option is a possibility, but we don't advise it. And the reason for this is that it has become clear that the ESTA algorithms keep track of an awful lot of information, and we have been seeing artists who are coming to the US to showcase have their ESTA sort of miraculously revoked, in some cases in the hours before they're about to board their flight. And the effect of that being, if you say, I don't want to get a B1 visa, it's effectively the same as ESTA. I can go and do a showcase performance on ESTA, you're legally correct. But being legally correct doesn't help you when you get an email on your way to the airport saying that the US government has revoked your ESTA privileges and now you don't have ESTA and you also don't have a visa and you can't travel to the US. So because of these occurrences, we have determined that B1 is the proper status to go in if you're coming to the US to showcase, and this has been corroborated by Homeland Security and by the US State Department. They also take the stand that the B1 is the appropriate classification if you're going to showcase. I think I've covered that slide. Paul, can we move on? Okay, can't I just get away with going on without a visa? You can if you're showcasing. You can't if you're performing an official, or if you're performing a like a commercial performance. Legally, it's not allowed. You can get away with it. Some people do. Loads of people do. But the stakes are pretty high. If you're caught, you are going to have a lot of problems. It used to be that artists did this all the time. They came in, they had 3 guitars and an amplifier, and they said they're visiting their grandmother, and Homeland Security was fine with it. That's not really the case anymore. Every single day in my work, we're dealing with artists who arrive at the airport, claiming they're coming as tourists. Homeland Security, the officer at the airport Googles their name, associates them with an ensemble, a performing arts ensemble, looks up the gigs, sees that they've got gigs booked, and turns them away. So it's something to be careful about, unfortunately, that it's something we need to be very aware of the problems of. Okay, next slide, Paul. Okay, so assuming that you're not just coming to the US to perform at a showcase event, assuming that you are coming to do one of the festival events, or you've got other gigs surrounding IBMA, what kind of visa do you need? There are 2 main classifications that performing artists use in the US. There are P visas, P1 visas, which are the members of a renowned ensemble, P2, which are for Canadian artists who are coming in, and only Canadians, unfortunately, and P3 for artists who are culturally unique. Now, I don't know any artists who don't consider themselves culturally unique. But this will not be a useful classification for most people on the webinar right now, because what Homeland Security means by culturally unique is you're coming to the US to present something that is unique about your own country's culture. And it's going to be hard to convince the US government that a bluegrass group is presenting something unique about their own government, because their assumption is that bluegrass is American. Now, if you're a Balkan, if you're from Macedonia and you've come up with this amazing combination of bluegrass and klezmer, and that's what you're bringing, then, well, yeah, that might work as a P3. But if you're playing traditional bluegrass, it's probably not going to work that well, because again, that's considered to be an American style, and it's just going to be hard to convince them otherwise. It's possible and should be, and in a perfect world it would be, but it would be a hard argument. The O1 visa is for individuals. So if you're a solo artist, or if your principal renown is as a solo artist, and you're most famous for your releases and your performances under your own name, then chances are you should be getting an O1 visa. If you are in that situation, you're coming with a band or with a crew, they would come on an O2 visa. In most cases, an artist is not eligible for more than one of these. In most cases, there is one that's appropriate and the others are not. And that's so you just have to figure out which one is the appropriate one for you. Okay, next slide, please. Okay, so how do you get a visa? Assuming, again, if you're coming to the US to perform and you're not just showcasing, you actually need a proper working visa. It's a 3-step process. The first process is there's a petition that gets filed in the US. Some US entity has to file it for you. That might be a festival, it might be your agent, it might be your label, it might be your cousin, it might be your management, but somebody in the US has to file a petition. The purpose of the petition is to prove 2 things. First, that you are an artist who is eligible for that visa classification. If you're going for a P1, you have to prove that you have sustained international renown. If you're looking for an O1, you have to prove that you're an artist of extraordinary ability. If you're going for a P3, you have to show that you're giving a presentation that is culturally unique. Culturally unique, again, meaning culturally unique to your home country. So the first thing the petition has to prove is that you're eligible and that you have reached one of those standards. The second is you have to prove that you have bona fide employment in the US. And there's a bunch of different ways to do this, but generally it's a contract for a performance, or it's a contract with a US entity, like an agent or a label, that shows that you've got some compelling contractual reason you need to be in the US. So that's what the job of the petition. The petition is usually huge. It's often 100, 200 pages of supporting documentation. This is usually something that's assembled and filed by a festival in the US, or more commonly by your US representative, some US representative of yours hiring an agency or a lawyer to put it together. It used to be that this is something that was done in-house by a lot of festivals. It's gotten complex and difficult, and so sadly, many organizations now outsource this process to law firms, which of course has massively increased the cost of the process. The interesting thing about the petition part of the process is it doesn't really matter at the petition level whether you're a member of Al-Qaeda, whether you have a criminal record, whether you're a drug mule. None of that stuff really plays a part. All they're really concerned about is, are you famous or culturally unique, and do you actually have work? Once the petition is approved, notification of the approval is sent out to all the US consulates around the world and all the ports of entry. So they have record that this has been approved, and you have effectively what you could think of as a work authorization. You're allowed to work in the US. But then comes the second step, which is getting an actual visa. For everybody in the world, at least who is not a Canadian, Canadian's a little bit different. The trick then, once the petition is approved, is to apply for the actual visa at a US embassy. And what the embassy does is effectively says, okay, we've got the work authorization, so we know that you're eligible for one of these P or O visas. Now the question is there some reason that you're ineligible for it? And that's the point where your membership in Al-Qaeda, or your criminal record, or the fact that you lived unauthorized in the US through the entirety of the 80s, or whatever it might be, that's going to come back to haunt you at that point. And that's where they may say, well, you're eligible because you are a musician and you do have work, but unfortunately you're ineligible because of your criminal record. And that's where the visa gets denied. And this is determined at an interview at a US consulate somewhere in the world, presumably in your hometown or in a town nearby to your hometown. So that's step two. If all goes well there, you get a visa issued, and then you travel to the US. And for the most part, you're done. Technically, there is a third step, which is actually getting admitted to the US. Things can go wrong here if for some reason an officer at an airport doesn't believe that the petition was approved or doesn't believe the visa is legitimate. You can get sent home, but it's very rare. Generally, if you get through the visa getting issued into your passport, you're probably good to go. It's important to note that Canadians don't have to actually get visas to travel to the US. They have to get the petition approved, but they just arrive at the airport or at the port of entry and show that, and they are entered in a visa status, but they don't actually get a physical visa. Let's move on to the next slide. Do I need a sponsor? Yes and no. For employment visas, you need someone in the US or something in the US to file a petition for you. Technically, it's not a sponsor. Technically, it's a petitioner. Be a little bit careful about who you seek for your petitioner, because depending on how the petition is filed, you may be obligated to only work for that one entity. This is something that agencies tend to do. They say, well, I'm going to pay for your visa, which is good, but I'm going to be your petitioner, and I'm going to file the petition in such a way that if you decide to bail from my agency and go work with another agency, it will invalidate your visa and you have to start over again. If you've paid for the visa, that's a hassle. It needn't be filed that way. There's other ways to do it. So just be a little bit careful about how and with whom you file a visa petition, just because of how that may ramify if your circumstances change down the line. Next slide, Paul. There we go. How long does the process take? Okay, right now, sort of miraculously, the petition part of the process is taking about 3 weeks, which is about the fastest I've ever seen in 20 years of doing this. So that's really good news. We're very rarely having to pay the expediting fee, which some of you know about the premium processing fee, which costs a crazy amount of money. Almost everything's getting approved pretty quickly. That's the good news. The second part of the process, the consular processing at embassies, depending on your circumstance, if you're white and middle class and middle-aged and you're applying in an EU embassy, you're probably looking at a week or 2 for the processing time after your interview. If you're young and Black and African or Middle Eastern or South American, you may be looking at a significantly longer delay as they do security clearances and evaluations of your documentation and all this kind of stuff. So it's going to vary an awful lot. But the key, it's very rare that I see a petition denied and visas denied. That happens pretty rarely, but what I very frequently see is people starting too late and running out of time. So that when anything goes wrong, and things always go wrong, getting to the point where there's no time left for things to go wrong and tours getting canceled because you just simply ran out of time. So rule of thumb, if you're looking for a P or an O visa, best to leave about 4 months. Start 4 months out, you'll probably be safe, unless you've got a criminal record, in which case that's probably not going to do it. You're going to need 6, maybe 7. Next slide, please. Great. What if I'm denied? Again, if you have a career, if you've got albums out or toured internationally or significantly within your country, there's press, all those things, or a fairly sizable selection of those things, your petition is probably not going to be denied. Your visa will then probably not be denied either, unless there's something going against you, like a criminal record, like a visa overstay in the past, like a racial or economic profiling that might be affecting somebody coming from a developing economy, or a country that the US finds threatening these days. But provided none of those things apply, the petition's approved, you're good. They almost always are, for people who are reasonably qualified, and the visas tend to be approved as well. Next slide. How long does a visa last? Okay, that's an important question. There's a lot of confusion about that. The P visas, which are for members of groups, can last for up to a year. The O visas for soloists and their backing bands can last for up to 3 years, but they only last as long as you've proven you have a contractual need for the visa. So if you're a band, you've got 1 gig, and you apply based on the contract for that 1 gig, you'll probably get a visa that lasts 3 or 4 days to cover that gig. On the other hand, if you're a solo artist and you're signed to a US agent and you file a petition based on your contractual relationship with that agent covering the 3 years and their commitment to book gigs for you for those 3 years, chances are pretty good you can get the full 3 years. So there's a lot of options and a lot of different ways to strategically file a petition in regards to how long you want it to last. But know that you're not, the full 1 year and 3 year durations aren't going to happen without working for them. Next slide, please. Who can help me with this process? Okay, there's a website that's paid for by the National Endowment for the Arts. It's started by the American League of Orchestras and maintained by folks from the American Immigration Lawyers Association. It's called www.artistsfromabroad.org. It is the definitive layperson's online source in how to navigate all of these visa issues. When Trump starts a new travel ban, there's going to be information about that day or the next day about what that means for performing artists. There's also a lot of information there about taxes. So if you are at a point where you're going to be making money in the US and are wondering what the tax implications of that income are, you'll be able to find information about which taxes are owed, how they're owed, how to limit those tax liabilities. That's all on that website too. The other source of information is my organization runs a hotline, a legal information and assistance hotline called Tamizdat Avail. And while Avail can't start you and take you through the whole process of getting a visa, its purpose is really to help people who are in the process and run into a snag, help them figure out how to get around that. So you file a petition and you get a request for evidence. You're at the border and the drummer is being denied entry and you can't figure out why. You need somebody to help. There's an email address. If you go to Tamizdat Avail, there's an email address and a phone number. You can call that phone number and you'll get a live lawyer who will attempt, at least, to help you solve your problem. Next slide. This is a little plug that for the work that Tamizdat's doing that isn't just helping artists directly. We are very involved with advocacy and research trying to make this process better. If you're interested in some of the work that we're doing, a lot of it's research on the legal issues that are facing performing artists and helping provide documentation and information about problems with the process to advocacy organizations around the world. If you're involved with an advocacy organization or an artist coalition of some sort, and you want to be involved with the process of trying to make this this nightmare less nightmarish, let me know, because we'd love to work with you and give you some of the information that we're working on. Yeah, next slide, please. Taxes, I just mentioned that briefly. Very basically, foreign performers should expect to have 30% of what they're guaranteed or what they're paid withheld. So if you've got a $3,000 guarantee for a performance and at the end of the night the club owner hands you $2,000, you shouldn't be surprised because that is the law. In folk and in bluegrass and in the more independent echelons of rock and roll, very frequently this isn't enforced and people get paid in cash or pizza or beer, and they don't see that 30% withholding, but it is legally required. So a lot of venues do it. There is a way around it. Sort of, you can do something called a central withholding agreement if you're going on a tour in which you negotiate a taxation rate with the US government before you travel, which could limit the amount that they withhold, in some ways getting rid of the withholding entirely. It's important to note that this withholding is a withholding. It's not necessarily a tax. So you're gonna have 30% withheld during a tour, and then if you file your US tax returns at the end of the year and can show that you took a loss or made no profit, you'll get that 30% back. Most artists don't do that. Most artists just eat that 30% because it's too much of a hassle to try to get it back. Part of making this whole thing work is getting a US Social Security number. There's information about how to do that on the Artists from Abroad website. It just makes the whole thing a lot easier. So if you intend and expect to be getting paid in the US on a relatively regular basis, it makes sense to get a Social Security number just so you can fight the battles to get your money back if you want it. Next slide. Right. This is again an impassioned plea for trying to keep the U.S. borders permeable to culture. It can be very discouraging. My politics are going to become obvious here if they haven't already become. It can be very discouraging trying to promote the arts in the U.S. right now, promote international arts in the U.S. right now, just because the administrative barriers are less predictable and more substantial than I've ever seen in 25 years of dealing with this. But I think it's really important to note that that doesn't mean we should stop or give up. As international artists, this is the cultural diversity you're bringing to America is critically important in keeping the kind of growing xenophobia that we're seeing in the US, keeping that at bay. We need you, and we need the culture that you're bringing and the cross-cultural conversations that you bring with you. And it may seem like a small thing, but it's not. Your presence in the US is part of what we need to work together to do to keep the darkness at bay. I think that's it. I think we can open it up to questions.
Thank you, Matthew. Yeah, there was one from Maria Wallace who asked, "What if I wanted to bring an instrument to a U.S. bluegrass festival and join in the jam sessions? Based on your initial intro, are you saying that UK visitors would actually need a work visa to participate in festivals in this way?"
Okay. There is one exception. I mentioned at the beginning, you start from the assumption that you need to, in which case, yes, if you're playing a jam session, you should. But there is an exception that relates to amateur performers or amateur artists. So theoretically, if performing on that instrument or performing as a musician is not something you typically get paid for in your personal life, if you are an amateur, you're not a member of a musicians union, and you're just bringing your instrument to play, theoretically, you don't need to get a working visa to do that. The concern is that anybody entering the US with a musical instrument is suspect that they are coming to tour and perform for employment. So at the very least, I would make sure to bring documentation of the event that you're playing and make it very clear that you are just joining in. You're not getting paid. You're informally joining an amateur jam session that is not it's not part of any professional engagement. You have no contract. It's you won't be missed if you don't show up. If the jam session is something that's happening, that's more official than that. If it's effectively a performance that you're contracted to do and you're joining and it hasn't been rehearsed because it's a jam session, but maybe it's been advertised, your name's on the advertisements, people are paying money to buy tickets to see this jam session, that is a real performance, even if it's not rehearsed and even if you're not getting paid for it. And yeah, you should have a P or no visa legally to do that, which isn't to say you can't get away with it, but you have to know that when you're entering the US, if they start asking you questions and if you answer those questions truthfully, you may get turned away. I hope that answers the question.
Great. Thanks, Matthew. There was another one before I open up the lines. George Jackson had sent in a question. Maybe it was more directed to the IBMA specifically, but first of all, he gives you kudos, Matthew. It's George Jackson's a New Zealander. He's living in the U.S. currently, and Covey Law helped him get his O1 visa, so he thanks you. And he's a musician, and he's also a booking agent for U.S. bands traveling to Australia, New Zealand, perform, and temporary work visas for traveling bands have gotten easier to get for artists traveling to Australia recently, which is, as he says, is excellent. He says he's processed 6 for artists that he's booking in the last week at around 280 Australian dollars each. And so, then his question for us, and I mentioned this so that everybody on the line, if you're thinking the same question, I figure I might as well put it out there. He's asked that to us, given the prohibitively high cost of working visas for bands traveling to the U.S., would the IBMA look at a grant of some kind for 1 or 2 international bands a year to help bands meet these costs? And the answer to that question is it's something we have begun to look at. It's also pretty cost prohibitive for us to get into that. And I know that sounds difficult for some people who say, gosh, it's me individually versus an organization. But, our budgets have been historically very tight in terms of our, any excess cash flow that we would have for such things. But given the priority of that, we're going to be exploring potential avenues now that the IBMA has moved over to becoming in the U.S. we call it a 501c3 nonprofit organization that can seek grants elsewhere. And so, as we're looking for potential grants who might, in the arts, there may be something out there that we can identify to help artists come in to perform here. So there's nothing been identified yet, George, or for any of the rest of you on the line, but just please know we understand that it's a tall order for you to pay for the process to come in here, and we're going to be assessing this over some time here. So we appreciate the interest on that. So are there other?
Can I just add something
to
that?
Yeah.
It's really important to understand that the costs of these P&O visas are legendary. Everybody complains about them, and rightfully so. But it's important to realize the actual cost of the process, meaning the filing fee to the government, the union fee, and then the fee paid to the embassy to get the visas issued, is really a fraction of the all-in costs that people resist, which is principally expediting fees, which are not that necessary right now because the process is working very quickly, and attorney fees. And the attorney fees, to me, are the things that have gotten the most kind of prohibitive in the last 20 years. 20 years ago, people never hired attorneys to do this work because it wasn't that hard. The process has gotten so unpredictable that people hire attorneys, and I've seen attorneys charging as much as $10,000 for an O1 visa, which is too much as far as I'm concerned. But so when an organization is looking to how to resolve this, one of the things they could be thinking about is, how do we avoid those attorney fees, which means either doing it in-house. If you've got a board member who's an attorney who can help with this process, that might be ways to keep the costs down. And some organizations have done that.
Right. So I'm just opening it up for other questions that may be out there. Anyone want to raise their hand to ask a question? If you can do this on your on the panel there that you have open, you can raise your hand. You see a little hand by your name. You can click. Okay, we have Eugene O'Brien has a question. Let me see if I can it looks like you've muted yourself, Eugene. Can you? Because oh, there you go. Okay, Eugene.
Okay, you got me?
Yes, we can hear you.
Okay. Yeah. Two questions. Can you please say a little bit about the letter of support that's required to go with a petition that's got to come from a labor organization, and which organization would be able to do that? And the second question is, does a petitioner have to be a recognized company, organizer, agency, or can a US citizen act as the petitioner? Can an individual person act as the petitioner?
Right, those are both really good questions. In regards to the labor consultation or peer recommendation, that is, I didn't mention it, but there's a whole lot of things that go into filing a petition. And I didn't really go into that much because it's kind of a bottomless pit of detail. And since people normally don't do it themselves, they usually outsource that, I figured I didn't need to go into that. But one of the elements that has to be included with a petition before it goes to the government is a consultation from a relevant labor union. And that means the petition is submitted to a labor union, they look it over, and they do an evaluation of whether they think that the artist for whom the petition is being filed is important enough that the American interest in having that artist in the US outweighs the ostensible damage that artist is doing to the US labor market. In 25 years of doing this kind of work, I have never seen the American Federation of Musicians deny a visa or denied a consultation to an artist that I was working on. They do in certain situations. Primarily, they deny consultations to international orchestras who are being hired at under union scale to perform soundtracks for Hollywood films. That's sort of the main thing they're looking at. But as far as bluegrass musicians, folk musicians, jazz musicians, rock musicians, you pay them $250, and if it appears to them to be a legitimate artist who's doing legitimate work, they will issue that consultation. It's a hoop you have to jump through, but it's not a complex or particularly difficult one. They are very accommodating. There are other unions that make life much more difficult. Actors' equity in theater is incredibly difficult to work with and frequently denies consultations for actors, but that's fortunately not our problem here. To the other question, what was the other question?
The other question was, does it necessarily have to be a professional agent or organization to be a petitioner, or can an individual in the US, an individual citizen, US citizen, be a petitioner?
Right. Legally, it could be any U.S. entity. So a U.S. citizen, a U.S. corporation, LLC, whatever it be. It could be anything. There is a slight risk of having somebody who's completely unrelated to the profession file the petition in that, well, there's two risks. One, it's conceivable that Homeland Security, in reviewing the petition, would say, well, what does this person have to do with this? Why is this happening? But that's unlikely. They generally don't care. The bigger concern is that if you have a situation where the petitioner is not the employer, it makes the petition legally more complex. And you'd want to make sure if the entity filing or the person filing the petition doesn't have a contractual relationship with the artist, you're going to want to make sure that they spend some time digging around on artistfromabroad.org, because there's going to have to be an explanation of who they are. Effectively, there's going to have to be a document in there where the actual employer and the artist authorize in writing the petitioner to act on their behalf as an agent. So there's a bunch of stuff you get into, but this is, again, just hoops to jump through. There's no reason to not do it that way. You do not need a bona fide agent or label to be the petitioner. I think that's an answer. I hope that was
yeah, that's cool. Thanks.
Sure. Any other questions?
So thank you, Eugene. We're getting close to the end time for our call, and I want to leave at least a minute here at the end for Eddie to just recap kind of the showcase process for those who want to showcase. But there were a couple questions. I can probably take one of those. And Maria, you had your hand up first. George, you had your hand up, but maybe you can send the question to me, and I can relay it on to Matthew as well. But Maria, what is your question?
Hi there. I don't know whether it really counts, perhaps because it's not a performer query, but it's sort of related. I did write it in the question panel, but I'm a music promoter. That's become the thing that I do over here in the UK, like I'm booking agent. I'm working with a few American and Canadian bands touring here and booking tours for them. And as you know, the process is much easier and more cost effective in that direction. My question was, I was thinking of coming to IBMA this autumn, and some of my friends and contacts had suggested maybe being involved in in the business conference, perhaps one of the seminars, in terms of what I've got to say about bands coming over to the UK being interesting, being for the audience. But it's occurred to me, would I need a work visa I know it's not really.
Yeah, no, that's a good question.
I thought, oh my God,
Yeah.
I mean, obviously I wouldn't be getting paid or anything, but
right.
I'm not sure where to go to find that out.
Right. I would be happy to have a conversation with you offline about that. The answer effectively is yes, legally you should. In practice, I don't know of anyone who ever has gotten a work visa to just show up and speak on a panel. Technically, if you do the analysis, there's no reason they should get away with it, but Homeland Security doesn't seem to care. But we can talk about that in more detail. Feel free to just drop me an email and we can get on the phone about that, because it's just important to know about it, but it shouldn't be a problem.
Yeah. And so, Eddie, and if we have another minute here, we'll try to get to you, George. But Eddie, can you just, for those on the line, just make sure you walk through kind of the process for the application timeline and the committee timeline, if known, and just how it all works, how bands are selected, just so everybody's aware for the official showcase side.
Oh, sure. Yeah, happy to, Paul. So we currently have our application open, as many of you may know, and it's available through our website at ibma.org. And so the application process is completely online. You submit, the basic info, audio sample, artist bio, et cetera, et cetera. But we have an online form where it collects all that stuff. And then, so we then deliver that or give access to all those applications. And just for reference, we receive, roughly, 150 to 160 applications and select 30 bands as official showcase artists. And that selection process is by committee. It's a committee of 4. Usually composed of a couple of talent buyers, somebody in radio, and trying to think who the fourth one is. Maybe right now we have an artist. We usually have an artist member on there as well. And so they review all applications and score them based on, who they think are the best fit, who have the best, are in a good position to showcase, have, things like having a record out, who's going to benefit from the platform and whatnot, and who's, seems, to be at the point where they'll get a lot out of it. And so they go through, score all the bands, and then we, get together on a conference call, and they sort of hash it out and make that selection. And we usually have that wrapped up. Well, to back up, I'm sorry. The application is open until the end of February, so February 28th. The end of the day. Usually we don't really shut it down until March 1st, but and so then the month of March, the committee spends that time reviewing and scoring and selecting the acts, which we are usually able to notify all bands. We notify all bands whether they're selected. We select 30. We select 10 alternates, and then we notify those who were not selected. So we notify all applicants typically by March 31st. We kind of in our information we say by May, but we're usually able to do it by the end of March and try to usually have everyone confirmed by the end of April. And if we need to dip into alternates, we're usually able to sort that out by then as well, unless something happens further down the line, which has occurred in the past. But yeah, so application open until the end of February. So we got a couple more weeks, and then notifications typically the end of March, first part of April. Is there anything else, Paul, that you would like to?
No, that's great. That's great. Well, we hope we know it is it's a complicated process. It's not all that it's not inexpensive, but it is really exciting and rewarding to have the international community come to World of Bluegrass and showcase, and it energizes everyone around the entire world of bluegrass when we have international artists performing. And we hope you can. We're here as a resource for you with questions. Eddie's email is eddie@ibma.org. Mine is paul@ibma.org. We keep it pretty simple around here on the email addresses. And we're here to try to be a resource. I mentioned early on in the call that Eddie, along with Matthew, are working to finalize both I hate to call it a white paper, but at least an informational paper around this visa process that Matthew has provided here today on the call, as well as trying to just revise a letter that we've provided to artists as well, so that you'll be equipped to go to the consulate if you're seeking a B1 as an example for showcasing. So we want to be here in any way we can. Please contact us. Obviously, Matthew makes himself available too for people to, when you need help, as George Jackson has raised his hand and said, he's helped him. So, Matthew, we thank you again for all of your work you've put into preparing for this call, helping us here in the office become more aware of the nuances of this, knowing that there are a lot of both the letter of the law and the practical application of the law that is so important for everyone on this line and everyone else to kind of get our arms around. And it seems to be an ever-moving process. And so your insight and expertise is valuable to all of us. And so we thank you for doing this today. And we will try to make this recording available as well. But like I said, we will also have this paper out for everybody to look at. And please contact us if you have any other questions or other information. So with that, we thank everybody, and we'll sign off for now. And you all have a great day. Take care.
Thanks much.